Hi, folks. Welcome to Crisco's Corner. Supreme Court rules unanimously for Trump in Colorado ballot disqualification dispute. Those of you that weren't aware, the Colorado Supreme Court, I believe, upheld removing Donald Trump from the November election in Colorado. Supreme Court decision to affect more than 30 states that have considered challenges to remove Trump from the 2024 ballot. Illinois just did it a few days ago. Yeah, it's this is huge. This is huge. This is just one step in a series of steps that have to happen. The absolutely ridiculous and unlawful, I believe, $500+ million penalty in New York. The trying to overthrow an election case in Georgia, which has turned into a reality TV show. And there's others as well. It's just ridiculous. Absolutely ridiculous. Let's read on. The U.S. Supreme Court sided unanimously with ultra-liberals on there, mind you, with former President Trump and his challenge to the state of Colorado to attempt to kick him off the 2024 primary ballot. That would also apply. Now they're going to say, well, this doesn't apply for the general. It does. All 9 justices ruled in favor of Trump in the case, which will impact the status of efforts of several other states to remove the likely GOP nominee from their respective ballots. Now, the primary ballot wasn't a big deal because the Republicans in each of those states that did that or tried it could just turn to a caucus where you wouldn't be a ballot. It's different. So he would have got the nomination anyway. This was really about November. The court considered for the first time the meaning and reach of Article 3 of the 14th Amendment, which bars former office holders who engage in insurrection from holding public office again. That was put in right after the Civil War, when many of the Confederate leaders, I forget the one guy's name there, Stevens, was the Confederate vice president, and when he pledged oath of allegiance again and his state was brought back into the Union, he ended up in Congress again where he came from. And a lot of the congressmen are really pissed because of the fact that this guy took up arms against the United States. So that was put in. That's what that was really put in for. And they even put a caveat in it. If 2/3 of the House says it's okay, an individual can come back. Challenges have been filed to remove Trump from the 24 ballot in over 30 states based on the insurrection clause, which he was never charged with, let alone convicted, never charged. We conclude that states may disqualify persons holding or attempting to hold office, but states have no power in the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. Now, that's about as plain as English as you can make it. Well, we'll see what these mental pygmies do. Or they just simply ignore it. Is Biden going to tell the DOJ to force the state to put somebody on the ballot to his opponent? This gets real dicey. Colorado Secretary of State issued a statement Monday in the opinion saying the United States Supreme Court has ruled that states do not have the authority to enforce Section 3 of the 14th Amendment for federal candidates. In accordance with that decision, Donald Trump is eligible candidate in Colorado's 2024 presidential primary, she said. That wasn't really about the primary. Trump reacted to the ruling in his post on Truth Social saying, big win for America. The state of Colorado argued because they determined Trump's behavior related to the 2020 election interference, culminating in the January 6th Capitol riots, amounted to an insurrection, which he was never charged. And that was the point. Basically, the way it works is when you're impeached, it's like a grand jury, and they go before trial in the Senate. And both the times he was found not guilty. The Supreme Court, however, said state enforcement of Section 3 with respect to the presidency would raise heightened concerns. Conflicting state outcomes concerning the same candidate could result not just from differing views on the merits, but variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. The result could well be a single candidate could be declared ineligible in some states, but not in others, based on the same conduct, in fact, even the same factual record. The patchwork that would likely result from the state enforcement would sever the direct link that the framers found so critical between the national government and the people of the states as a whole. The disruption would be all the more acute and could nullify votes of millions and change the election result if Section 3 enforcement were attempted after the nation has voted. That's correct. Nothing in the Constitution requires that we endure such chaos, arriving at any time or different times up to and perhaps beyond the inauguration, he continues. Justice Amy Coney Barrett, in a concurring opinion, wrote, the court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writings on the court would turn the national temperature down, not up. For present purposes, our differences are far less more important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. Now, what is MSNBC, CNN, and all the rest going to say? The far-right, mega Republican Supreme Court. Well, wait a minute. They can't use that. That's why they didn't issue the ruling in person. I guess they usually do. They just released it on their website, probably for security, and that's what everyone was speculating. Why aren't they doing it in person live? Because they're worried about security. Well, we know as a general rule, 99.9% of the time, conservative people don't take up violence. Whereas 100% of the time, when something like this, progressives and Democrats take up protests and violence. In more than 2 hours of spirited, often tense arguments last month, the 9 justices asked tough questions on both sides about whether the president or presidential candidate is exempt from the constitutional provision adopted after the Civil War. Justice Brett Kavanaugh spoke for his colleagues when saying they were confronting difficult questions. When you look at Section 3, the term insurrection jumps out. When you look at Section 3, the term insurrection jumps out. And the questions are, what does that mean? This is Kavanaugh. How do we define it? Who decides? Who decides whether someone engaged in it? Kavanaugh noted the courts look at this question in an 1869 decision known as the Griffin's case, which found that an act of Congress was necessary to enforce the 14th Amendment's ban on insurrectionists holding public office. I'm not sure if anybody was really and truly banned. I know Stevens, the Confederate vice president, ended up sitting, but these are difficult questions. And you look at right at Section 5 of the 14th Amendment, it tells you Congress has the primary role here, Kavanaugh said. I think what's different is the process, the definition, who decides questions really jump out at you when you look at Section 3. Yes, you have to be put on trial and accused of insurrection. Chief Justice John Roberts questions Colorado's Attorney Jason Murray about the consequences of the state's position. What do you do with consequences of your position? There will be disqualification proceedings on the other side, and some will succeed in very quick order. I would expect that a goodly number of states will say, whoever the Democrat is, you're off the ballot. He said that would then come down to a small number of states deciding the election. That's a pretty severe consequence, and he's right. I don't normally agree with Roberts. He's a little too wishy-washy for me. Justice Samuel Alito pressed Murray to grapple with what some people have seen as the consequence of the argument that you are advancing, which is that there will be conflicts in decisions among the states. The different states will disqualify different candidates. I'm not getting a whole lot of help from you about how this would not be an unmanageable situation. Well, what they'll want to do is just keep Trump off, and then we'll say, well, let's amend the law a little bit and make it clear in the court as long as we get rid of Trump. Just like the immunity stuff. And that's going to end up before the court as well. And that's really huge. And that has really severe implications, even bigger than this. Every single president in my lifetime that's still alive can be brought up on war charges. Barack Obama, for one. If this immunity is thrown out, Barack Obama can be brought up on charges that he killed an American citizen, a 16-year-old boy, whose father was a terrorist. But he was an American citizen, the young boy. And when the drone struck and killed his father and many others, he was killed as well. He did nothing wrong. He had no due process, nothing. In fact, the rumor goes that one of Obama's people, when they were confronted about the fact that this kid was killed by Obama, said flippantly, well, he should have had a better father. Yeah, every single one. George W. Bush, Bill Clinton, Barack Obama. All could be charged under war crimes. And in fact, there's many in Europe, in the EU, in the parliament there, that want to put up Bush for war crimes. Not Obama, of course, because he got a Nobel Prize for, wait for it, doing nothing. Anyway, folks, there it is. The Supreme Court rules unanimously. I don't think the immunity case is going to be unanimous. My guess on the immunity case, honestly, because of the far-reaching repercussions of it, will be 7-2 in favor of Trump. But that's just my opinion. I'm not a lawyer. Anyway, folks, there it is. Just one step closer for President Trump to retake the presidency. One step at a time. How do you eat an elephant? One bite at a time. You got to start somewhere. Until next time, God bless, goodbye, and good luck.